for calling Gallagher Bassett. This is Charlotte. How can I help you?
Yes, this is McNeeley, and I see you called me. I was returning the call.
Well, thank you for giving me a call back.
Mm-hmm.
Give me 1 second. Let me pull your file back up, okay?
Sure.
All right. Thank you for holding so patiently. I do have your file here. So I was following up. I understand that you spoke with Justin earlier this week in regards to our offer. And I just wanted to see if you had an opportunity to think about the offer that he presented to you.
Yes, he presented the offer of $500, and I've already spent more than that on gas and medication. And then there's the issue of the spinal cord injury, as well as the hand. The what did they say? It was a compound fracture to the hand. Um, So by the employee at McDonald's dropping a hot coffee on me, that made my pre-existing injuries a lot worse.
Okay. So in regards to the gas is not something that we would look at as far as reimbursement as part of the claim. What we would be looking at is out-of-pocket expenses related to medical treatment for related injury. Okay. Justin, I knew when we spoke last, I think it was in December or January, you stated that you sent medical records to their office, to Justin's office. They did not receive any medical records. I have requested them, but I have not received a copy after confirming that their office didn't receive them. So do you still have copies of the records that you requested from your doctors for treatment?
You sent me forms to sign, giving you guys permission to get copies of the medical records from any and all of my doctors. I signed those and I sent them back to the P.O. box, which was on the paperwork. The last I spoke with you, you said you received that.
Yes, but prior to that conversation, you stated that you had sent medical records to Manning and Cass' office, to Justin's office. Is that not correct?
I believe
Or
I
did
do have
misunderstand?
I believe I do have a certified receipt showing that they did receive those documents.
Okay. Do you have them in an electronic form, like maybe in an email or something, where you can send them to me? Because I requested them from the providers. However, it can take several weeks to possibly months before I receive them. But if you already have them and could send them to me, I'd be more than happy to review those.
Well, I've already went through this with another provider, and Huford Humphrey don't take that long to get people those medical records. So,
Okay.
I mean, there's a guy over there I talked to. In fact, I went down there one time, and he was like, "Hey, man, I've already sent those out." So I know Huford Humphrey are on the job by getting people the medical records.
Okay.
So, I
Well,
mean, if
I'll
you
wait for them to provide them to me then.
yeah,
That's not
they
a
do not
problem.
take that long to get those out. Yeah.
So then, in regards to the offer that we have presented to you at this time, we have, you know, reviewed your case and secured all the information at this time that we need out, other than the medical records, to confirm what injuries you have and any treatment that you sought.
Okay.
Okay.
Right now, from what I understand, my primary doctor is trying to order me a back brace for my back injury, my spinal cord, because it ain't gotten worse. And so I can't find one, in the stores or whatever, because they said they don't carry my size. So he's saying that he can order one, so they'll let me know when it comes in. Um, the lawyer yesterday, I think you said what was his name, Justin?
Yes, Justin is who you spoke with.
Okay, he said he was not aware of the video when a young lady admitted that she thought it was funny to drop hot coffee on me. And so I sent him that video as well as you. And I wanted to make sure you guys had all of the videos because those will be an exhibit following the complaint.
So are you filing a complaint, or you have an attorney that's filing a complaint, or are you trying to resolve this matter with us directly?
You guys, apparently the offer is too low, so you really don't leave me no choice but to pursue it in the courts, because even if I was to take this to small claims court, the maximum there would be $10,000. So you guys are on the hook for the injury due to the fact that I sent you a copy of the eggshell skull rule, and you are an attorney, correct?
No, I am not an attorney. Justin is an attorney.
Okay, and I did send him a copy.
I received the link as well of the link that you sent. But what Justin's involvement is he's assisting because you filed a subpoena instead of responding to my contact attempts by mail or phone call attempts initially. Okay, so I have reviewed and, based on the information we have, presented that offer, and Justin presented it to you based on that information. In our review of this incident, I know that the last conversation you had with Justin, you're alleging that the employee purposefully dropped or spilled the coffee on you. In our review, that was not the case, from what I understand, from your account, as well as surveillance of the incident. Now, we are considering the first-degree burn to your hand from the lid coming off of the cup. The other injury for the bone or fracture on your hand and the spinal cord injury, because we don't have those records right now, those injuries are questionable as to if they are related to this incident or not.
Those are considered pre-existing injury, and if you read the case of the eggshell skull rule, where the person who does something negligent to an individual, whether they knew about their medical background or not, is on the hook for the entire injury.
That's not what that states, but we're not even going to go into those documents that you're providing. What we're looking at is what happened in the incident, what were your direct related injuries. And then in the medical records, if medical records show that a coffee spill to your hand aggravated another injury, it would have to show in the medical records. But right now, I don't have those records to state that they are related.
Can you answer this question? Someone drops hot coffee in your lap, you're gonna sit still and just act like it doesn't bother you, or are you gonna move around? I'm pretty sure you guys know from your previous hot coffee incidents, people just don't stand still.
I can understand a reaction if hot liquid does touch your hand. Yes, I can understand you moving.
It was not just the hand. It started at the hand and it ended up in my lap.
Okay. Did you ever take any photos of your burn on your hand? Because I haven't received any or saw any photos of the burn or the coffee spilling on your clothing or body. Did you take any of those photos?
I don't know if I have any photos of that, but I definitely went to the doctor right after that. And then the manager who was in the window, I forget his name, he's a witness to it. He was right there. He was the one who refilled the cup of coffee and put it in a second cup and made sure the lid was secured on there.
Okay. So I understand you said that the $500 offer was low. What were you looking at, or what did you have in mind as far as trying to resolve this matter?
I told him yesterday if I was file this in small claims court, the maximum would be $10,000 there, and I don't believe I would be filing this in a small claims court. And I said we could start at around that area, which would have been the $10,000 in the small claims deal.
Okay.
Not saying that it had to be directly 10,000. I said we can start in that area. That would be somewhere to start from.
You talking about starting at 10 and going up, or you're talking about lower than 10?
In that area.
Okay. All right. Well, Mr. McNeeley, based on what we have, we are willing to resolve this with you directly. We are able to go ahead and make you an offer that is reasonable based on the information that we have right now for a coffee burn. Okay. But I would not be able to make an offer near $10,000 for this case. I just don't have that ability in the information that we found in this investigation.
I understand that. That's why they have the courts, because you can file your complaint in the courts and they'll get it resolved for you. I do understand that. But I'm not going to, say again?
No, I was going to say, if you could give me a number that you were looking at that was reasonable, I could review that and see if that's something we're able to do. But I nowhere near $10,000 on this case.
I understand. That's what happened with the old lady, and the courts found different. So, there's always the court's decisions. So, you guys already offered her $800, as I recall her on the internet. And so I do understand how you guys do what you do.
Well, each case is its own individual case, and we are reviewing the facts of your direct incident.
Okay.
Okay.
Like the video I showed you with my blood pressure number being 252. I've never seen those numbers before this incident, and from my understanding, those were pretty serious numbers. So there's the health problem, my previous health problem that goes along with this. There's no way we're going to avoid that. There's no getting around that. So I don't understand what you guys are trying to do. There is no way of getting around that. I sent you the eggshell rule. There will be no getting around that. Those injuries do exist. So
I'm not saying that your pre-existing injuries don't exist. What I'm stating is based on what we have in regards to what happened in the incident. Right now, I cannot state that a coffee spilling out of a cup onto your hand and on your lap caused for you to have a broken bone on the back of your hand and for your spinal cord injury to be worsened.
You can't see that?
I said I cannot.
You're right. That's what I'm making sure I understand what you said. You said you cannot see that. That's what you said.
No, we cannot. I cannot. Okay. Justin cannot.
All right, and it's a lot of things I understand you guys are not going to see. I understand that. That's just the way the defendants get down. I understand that. They tend not to see. That's why I have a case right now for fraud up on the court, because defendants don't want to see the truth. Sometimes you got to force them to see the truth.
This is nothing about not seeing the truth. We watched the incident. We watched your coffee be prepared. The employee prepared the coffee. They handed the coffee off to you.
Was that the second time the coffee was that the second time?
This is the first. This was the first cup of coffee that was handed to you by the young lady, not the one that was made by the manager when they replaced your coffee.
I'm listening. What does the video? Because I request a copy of the video. You guys still haven't given it to me.
Okay, I can follow up with Justin in regards to making sure that you do get a copy of the surveillance of the incident.
I've been ordered. I request that. You guys just shrug it off like it wasn't no big deal.
No, we received the subpoena for us to secure and preserve that evidence, and we have done so. So I will follow up with him to make sure that he follows up and gets you the surveillance as requested. He has to make sure that he's delivering it within the rules and regulations in your state, according to your subpoena that you filed for the procurement of that information.
Okay. What is the statute of limitation on personal injuries? Is it a year or 2 years?
It's different for state to state.
What about California? Are you aware?
Let me take a look.
Say again?
In California, there is a 2-year statute of limitation.
Oh, okay, because I thought it was 1 year. Well, like I know when you request those documents from Huford Humphrey, they do get on it because like I said, I've had other people request them and they did get them there. So I wouldn't understand why you wouldn't have had them by now if you requested them 2 weeks ago.
Well, like I said, I don't have them. I will review them once they come in. Once they come in, I can't make any guarantee that this is going to change our offer. But
I understand. I'm not gonna sit around waiting on the offer. I know what I have to do. I've been down this road before, so I know what I have to do as a plaintiff. So I'm not gonna just sit around and wait for you guys to play with numbers.
And it's not that that's what we're trying to do. We want to resolve this with you, but it's going to have to be something that is reasonable. And 10,000 is not reasonable. And even if you do decide you want to take the route of going through small claims court, there's no guarantee that they will review your case and state that it's valued at 10,000 or anywhere near that number.
And you're entitled to your opinion, because that's all that is, an opinion.
Okay, just like your request for 10,000 is an opinion of a number which you feel that you should receive for the incident.
Okay, so I don't even see why we bothering if we're bothering to even have the conversation of even trying to settle the matter if our attitudes are like that. So I don't understand what the purpose of the phone call.
Well, you're not. I'm explaining to you where we're at. We have that our store did not do anything negligent. You're saying that they intentionally threw coffee or dropped coffee on you.
Whether it was intentionally or non-intentionally, McDonald's is still on the hook for the injuries, because had she did her duty and secured the top on there and handed me the cup of coffee like normal people do instead of tossing it, that would have been a different story.
In the surveillance, the employee did not toss the cup. And
she pretty much let the cup go before I got a grip on it.
Okay, that is not what I observed in review of the surveillance. The spill did not occur until you took possession of the cup and brought it into your vehicle. But I mean, if you're willing to, try to resolve this with us and provide me with a different number, I can look at that like I stated. But right now, I'm not able to review this further at 10,000 until I have medical records.
Well, if you guys requested them from Huford Humphrey, and then there's the other, I don't know, I think I have to provide you with both doctors, my pain management doctors as well. And I signed your paperwork giving you the right to retrieve those documents, so that's all I can do for you. If you don't get them, or you're claiming you didn't get them, I don't know what to tell you. But that isn't on me. That's on you.
We did not receive the records that you stated that you provided to the attorney's office, to our attorney's office. That's what I said we did not receive. I said that
I will look for that certified, because everything I send out, I usually send it out certified. So I will look for the certified return deal, and I'll make sure I file that in the court as well to show that you guys did get, and all I got to do is show proof of service. So that's all I need it for. So I don't understand how you can claim you didn't get something when it came back signed. I've been sending certified mail out for the last 5 or 6 years to law firms, and nobody's came sideways like this to claim they didn't get one after someone signed for it.
Okay. Well, like I said, that's not the end of the road. I requested them based on the request that you completed, giving us authorization. Once that records come in, I will review it, and then I'll follow up with you.
Okay, so we're done here?
If there's nothing further that you would like to discuss about this case, then I will follow up with you once I have your records and review them.
Will do.
All right. If you have any other questions or concerns, just contact me. At this time, Justin is no longer going to correspond in regards to your case. He will refer anything that you send him directly to me, okay?
Is there another address on you? Because the only address I have for when I mail this complaint out, the only address I have, I believe, is that P.O. box.
That is our mailing address, is the P.O. box address.
So I could send it there and send it certified, and someone will sign for it.
I can double check as far as the certified. I'm not sure if
If not, you know what I'll do? I'll send it to the employer, McDonald's, where the incident happened, and I'll serve them with a copy, so they can get it and then they can send it to you. Because it seems like
it would be best if you send it directly to my attention, because if you send it to the store, there's going to be a delay in me receiving the information. Because, like I said, they're in California, I'm in Illinois. This is where your case is being handled. So I can definitely go ahead and email you my mailing information so you have that. That way you can provide it to the correct people that need to review your information.
Sure. If you would do that, I'd appreciate it to make sure we're on the same page with the address.
Absolutely. I'll go ahead and get that email out as soon as we get off the phone.
Thank you very much. You have a nice afternoon.
You as well. Bye-bye.